Digital evidence is everywhere today, from messages and emails to CCTV footage. But what happens when you need to submit it in court? Can all digital evidence be trusted? If you have ever wondered what goes into preparing digital evidence for a legal setting in India, then keep watching. Because today we are diving into exactly what you need to check before submitting any digital record in court. Digital evidence has become crucial in modern trials, with technology playing a big role in both civil and criminal cases. Whether it's a business dealing gone wrong, a criminal investigation, or even family matters, digital records often make or break a case. But here's the catch: not all digital evidence is created equal, and not all of it is admissible in court. This video will walk you through the steps to verify and validate digital evidence before you submit it in court. We'll cover what makes digital evidence trustworthy, reliable, and ultimately accepted by a judge. Before we dive into the details, here are the 5 key points we'll be covering today. First, authenticity verification, ensuring the evidence is genuine. 2. Reliability and integrity, understanding how to prove the evidence is untampered. 3. Chain of custody, tracking the evidence from source to courtroom. 4. Compliance with legal standards, meeting the IT Act and Evidence Act requirements. 5. Understanding rights if evidence is rejected. What to do if your evidence isn't accepted. Now, let's break down each point further. Authenticity is the very first check. It's all about proving that the digital evidence, whether a text message, email or photo, is real and hasn't been forged or manipulated. If this isn't clear, the evidence might be dismissed outright. Here is the way to verify the evidence. First, originality matters. For example, in Anwar PV versus PK Bashir, the Supreme Court ruled that electronic evidence needs a certificate under 65B section of the Indian Evidence Act to be admissible. 2. If you have a video or audio file, courts require proof that it hasn't been edited. An expert might be called in to analyze it and prove its authenticity. Now that we know that the evidence is real, let's make sure it's reliable. The court needs to know that the data hasn't been changed since it was first created. In order to ensure the integrity of the evidence, first use a hash value to confirm the digital file remains the same. Think of it as a digital fingerprint. If the hash changes, that means the data has been tampered with. 2. Recent cases such as Arjun Pandit Rao Kotkar versus Kailash Kushan Rao Gotkal emphasize that any breaks in the chain of custody can affect reliability. Courts in India now expect a secure chain to prove evidence hasn't been altered. The chain of custody refers to the path evidence takes from the moment it's collected to when it appears in court. It's like a paper trail that shows anyone who handled the evidence, ensuring that there was no opportunity to alter it. Why is this important is because first, in India, courts want a detailed account of the evidence handling. If someone can't account for the evidence journey, it may be dismissed. 2. Every custodian in this chain should document when they received and passed on the evidence. Even a small gap can compromise the evidence trustworthiness. In India, digital evidence isn't just evaluated for its authenticity and integrity. It must also meet legal standards. Both the Information Technology Act or IT Act and the Indian Evidence Act outline how digital records should be handled. In order to comply with the requirements, first, Section 65B of the Evidence Act requires a certificate for electronic records, certifying that they are generated by a reliable computer system. 2. Recently, the BSA 2023 introduced changes to how courts interpret electronic records, increasing scrutiny and on evidence coming from social media and cloud-based platforms. 3. Ensuring that digital documents meet these criteria is crucial, especially if the evidence is sourced from a third party. Imagine going through all these steps only for the evidence to be rejected. It's frustrating, but understanding what to do next can be empowering. In case your evidence is rejected, Here are the key steps you can take. First, if the evidence doesn't meet standards, courts allow a chance for resubmission with corrections. Reach out to an expert who can help verify the integrity and authenticity of your digital files. 2. In some cases, courts allow secondary evidence which involves alternate forms of digital record. For instance, if a primary device is inaccessible, a duplicate may be admissible. There has been significant development in digital evidence admissibility over the recent years. Just last month, updates under the BSA 2023 were issued, which further tightened the controls around electronic records, especially concerning social media and online platforms. Additionally, when data privacy concerns rising, courts are now more vigilant about accepting evidence sourced from a cloud services without user consent. These updates aim to protect individuals' privacy rights and ensuring that digital records are valid and unaltered. Digital evidence can be powerful in courts, but only if it is handled correctly. Let's recap. First, authenticity verification. Ensure the digital file is genuine. 2. Reliability and integrity. Prove it hasn't been altered. 3. Chain of custody. Maintain a secure path from creation to court. 4. Compliance with legal standards. Follow the IT and Evidence Act. 5. Know your rights. Understand your options if evidence is rejected. Remember, the strength of your case often depends on the strength of your evidence. Handling digital records the right way isn't just a legal requirement, it's key to justice. If this video helped you understand how to prepare digital evidence, please give it a thumbs up and subscribe for more legal insights. Share it with anyone who might benefit from this knowledge. And if you have any questions, drop them in the comments. I'd love to help. Take care. Bye.